That was the beginning of the prosecutor's closing argument in the Larry Whaley case out of Iowa. Now, there, Amy, he's saying that the defendant had, some scheme to kind of cook up a plan to shoot somebody that night, or at least he's trying to toe up to the line of that argument, saying that at one point the defendant said, quote, "I don't want to have to kill someone tonight." Now, we might agree on this, I suspect. I think that this is a bit of a stretch, because when juries, at least from my opinion, when they want to see evidence of a plan or that someone is thinking about inflicting harm or doing harm, they want to see more than somebody going to Walmart and buying bullets. And They want to see more than just a generic statement like that.
You can play it both ways, Aaron.
You can play it both ways.
That he was scared because of the other circumstances that have been brought up, people that he thought were after him who had allegedly been involved in shootings. So therefore he was arming himself to defend himself in advance. Or you could play it that he was arming himself because even though he said, "I don't want to have to kill somebody tonight," even that statement can be interpreted two ways. That why would somebody say, "I don't want to have to kill somebody tonight"? That's kind of a bizarre thing to say. So you can make the argument that maybe he did want to kill somebody that night or had an aggressive tendency that night, which is why he bought the gun, which is why he got the ammunition. And that statement was him sort of foreshadowing what he really did want to do, but saying, I don't want to have to, but I might have to. So you can really read into it both ways.
Yeah, and when you're on the fence, though, like that, you can read into it both ways. Is it beyond a reasonable doubt? I don't know. But we want to remind everybody, we're planning to go into the Anissa Weier sentencing hearing in Wisconsin. This is in the Milwaukee area. Again, this is one of the teenagers involved in the so-called Slender Man case. This particular defendant entered a plea to an amended charge back in late August, and we're at the point of sentencing now, and this was just one of these bizarre cases that had a lot of people scratching their heads, like, what's going on with this? You've got teenagers luring another teen and then attacking the teen, thinking that it would appease this fictitious character named Slender Man. So of course you have the whole host of mental health offenses, you have all these other issues, were they with it, were they not with it, were they impressionable, were they young, how does the criminal justice system deal with this?
Yeah, and it has all of those aspects of something that makes for good entertainment, and in fact there was an HBO documentary and so much press coverage, but below all of that sensationalism, I think it's a very tragic tale for everybody involved. Tragic, obviously, for this poor 6th grade victim who was stabbed and now has
what was it,
trauma
19 times, I think?
19 times. She has 25
and she miraculously
scars all over
survived.
Her body. Miraculously survived, and that's just a testament to the agility of youth. But she is traumatized for the rest of her life, and it was very touching and heartbreaking to hear the victim impact statement read by her mother about how this affected her, how she slept with scissors under her pillow, how she can't ever get close to anybody because she loved and trusted these friends at such a young age and they tried to kill her, how the physical scars she will carry with her forever. She can't even wear a bathing suit. I mean, just the trauma that the family went through is terrible, and clearly you have to take that into account when we see the sentencing today at the hearing, because even though it is very tragic that these other girls had these mental health problems, and that's been the determination that they were suffering from mental health and they should go to mental institutions to get treatment. Even though that's sad, you have to know that the impact on the victim is for a lifetime. And so one of the things that the mother said in the victim impact statement is, we want you to, she didn't even recommend a sentence for them in the mental institution, but what she did say is, please, we want you to take into account the fact that my daughter will be scared for a long time. And having these girls out, if they still have problems, or having them out too soon, we can't ensure that they've been treated. We don't know if they'll ever be healthy mentally again. Having them out soon will scare my daughter. She will fear for her safety and her life. So the longer that they're in an institution, on the flip side, that is peace and comfort for this victim, which she deserves, because regardless of whether they're out or in, she will always have to go through this trauma in her life. She will live with it forever. It has affected her tremendously because it happened at a young age. But her sense of safety will will be affected depending on how long they stay in these institutions. Her fear will be exacerbated if they're let out too early. And we want to make sure that the system treats them. And that if they don't get treated, they shouldn't come out. So I hate the fact that there's going to be a timeline on this. It should really be left up to mental health professionals. Yes, there should be a minimum amount of time, but if these girls don't get well enough where they can function in society, and one of them continues to have schizophrenia or whatever other mental disease or defect, they should not be let out because they will hurt again. And it won't be their fault because they're suffering from something, but it needs treatment until it's treated.
Yeah, though procedurally this was an interesting case because it was initially going to go to a trial, but then the defendant entered a plea, and the plea resulted in sort of a second kind of a trial. It was like a mini trial to deal with the mental health issues, and ultimately the decision in after the guilty plea, the decision in the mental health aspect of it is that she should be going for treatment and not going to prison. The victim's family wanted her to go to prison because part of this mental health treatment is that, in theory, as I understand it, she can petition the court to be released into the community every 6 months. And that's something that the victim's family, and presumably therefore the victim, are just not really comfortable with.
And like I said, I don't see how these jurors or even a judge or a court should be determining when somebody is released when they're in a mental health facility. There needs to be so many layers of checks by professionals to make sure that the person is completely cured or managed, and if they're not and they're going to be released, that they are supervised and not a threat to not only this poor girl and her family but to society and to other people. I mean, the fact that we are so hesitant to put people in mental health facilities that need treatment, I think is a little bit extreme, and that is a byproduct of the fact that we over-incarcerated, we over-admitted people way back when. I mean, I remember reading stories, 30, 40, 50 years ago that women who wouldn't do chores around the house were thrown in mental institutions. That's an extreme example, but that's why now we have the court system so ill-equipped to deal with people who genuinely need help. So I think rather than put all of this in the courtroom, I think it needs to go through checks and balances in the medical system.
Yes, I mean, the nexus between technology and law and mental health treatment and law oftentimes breaks down, or perhaps I shouldn't say that. Perhaps I should say it's not as fluid as perhaps it could be.
We always hear there are so many people with mental health problems in prisons and they're not getting treatment. And then they're released back into society. Yeah,
and that's exactly what the victim's family said here in the Slender Man case. Part of this family released when the jury returned the verdict that ultimately this would be a treatment rather than an incarceration in regular full-blown prison. Part of the family statement said, the potential release of an assailant that methodically planned and executed an attack in which our little girl was stabbed 19 times, puts the community and our family at risk. It is deeply disappointing. Yeah. So that hits the nail on the head.
But they actually wanted mental health treatment. Peyton, the victim, wanted and thought it was more appropriate to get them mental health treatment. But what they're saying is, then let's do it right. Let's not just throw somebody in there and then these jurors who have no experience, or a judge decides how long she stays, and then she can petition every 6 months just because they've hit the 6-month mark. She should be treated and evaluated, and if they are not well, then they don't come out. Or if they come out, they're under tight supervision. Or they can come out and do outpatient treatment, something like that. But I don't know that we have that type of teamwork between the court system and the mental health system.
Well, it's going to be interesting.
Facilitate.
It's going to be interesting to see how this sentencing goes as soon as it starts up. Again, we're planning to see it any minute here on the Law&Crime Network coming out of the Milwaukee, Wisconsin area. I mean, it could be that the judge says, okay, I'll do these every 6-month status checks, but how deferential is the court system to the professionals who are doing the treatment?
That's the question.
If the court system is going to give heavy weight on the professionals doing the treatment, then maybe there's not an issue with it happening this way. It may be that the court system is going to look at this and say, hey, look, this was pretty serious. We're going to keep the lid on this particular defendant for quite some time. Yeah, okay, they get the due process guarantee of being able to petition, but look, I mean, when I worked in the state attorney general's office, we were constantly getting petitions from people in prison or other kinds of treatment who wanted out, and of course, we just went to the judge and said, look at what they were accused of doing, and we had one who had entered a bunch of guilty pleas who kept trying to petition to get out, and it's like, wait a minute. Of course, the judges just looked at it and said, okay, you get your crack at the petition, I took a look at it, forget it, you're staying in prison. It may be such a case here where the defendant then ultimately stays in treatment for quite some time.
Yeah, and you're not going to have a battle of the experts like you would have in a trial, because you have one facility treating her, you have professionals at that facility intimately involved in the treatment, and they're going to be the ones weighing in, and it's sort of like what you have with parole. When you go to parole hearings and you look at how's the person behaved, and what have they been involved in, and assess whether they're a threat to to society.
Yeah, we got to cut in now because it looks like this hearing is starting again. This is the Anissa Weier case out of Wisconsin, the Slender Man defendant sentencing.